The proceeding will start.
Order. Good morning and welcome to another virtual meeting of the Public Administration and Constitutional Affairs Committee. I am here in a committee room in Portcullis House with a small number of staff required to facilitate the meeting, and my colleagues and our witnesses today are in their homes and offices across the country. The committee is extremely grateful to our three witnesses on our panel this morning for making time to appear before us. I wonder if I might ask the members of the panel to introduce themselves for the record, starting with Professor McHarg, please.
Good morning. I am Aileen McHarg. I'm Professor of Public Law and Human Rights at Durham University.
Thank you. Raphael Hogarth, please.
My name is Raphael Hogarth. I'm an associate at the Institute for Government.
And Dr. Cormacain, please.
Good morning, my name is Ronan Cormacain. I'm a research fellow at the Bingham Centre for the Rule of Law, and I'm also a consultant legislative counsel.
Thank you ever so much. My colleague John Stevenson is going to start off with the questions today. John.
Thank you, Chair. Could I start with you, Dr. Cormacain? Was there enough accountability in the way that the legislation, the Coronavirus Act, was introduced and passed? Do you have any concerns about the speed at which the legislation was enacted?
The short answer to your question is I am concerned about the speed with which it was enacted, but I think that you asked about accountability. What we're talking about really is proportionate accountability. So it's not an absolute value. In an ideal world, we would have a large amount of time to debate these matters in Parliament, but given the circumstances of the pandemic, I think it was reasonable for it to be passed at breakneck speed. So that is something which applies to the Coronavirus Act itself. I'm not sure if you want me to discuss the subsequent regulations which flow on from that, but for the Act itself, when it was passed, that was sufficient, I would say.
Thank you. Professor McHarg.
I would agree with that. There's a long history of emergency legislation being passed very quickly. This was about 6 days, I think, from first reading to royal assent, which is not unduly fast. And there was the bill was amended, so I think we can say that the scrutiny process at least worked to some degree. So I think it's inevitable in these circumstances that we're going to see emergency procedures, and that we're going to see quite a lot of executive dominance in this process. That's by no means unique to the UK. That's a phenomenon that we see, in every jurisdiction that has faced this pandemic or similar crises.
Mr. Hogarth, your observations.
Yes, I agree with what's been said. I mean, I draw a very sharp distinction between the level of accountability, as Dr. Cormacain said, in the introduction and passage of the Coronavirus Act, where there was some genuine parliamentary scrutiny. There were amendments on things like religious burials and parliamentary review periods, and the enactment of the restrictions regulations, i.e. effectively the rules that gave effect to the lockdown, where there was really no accountability of that kind, no amendment and parliamentary consideration before the fact. So I'd say yes, in the circumstances, a reasonable amount of ex-ante accountability for the Coronavirus Act, but concerningly little for the restrictions regulations that gave effect to the lockdown.
Thank you. Can I go back to you, Dr. Cormacain? How do the provisions of post-legislative scrutiny in the coronavirus legislation compare to those contained in the existing emergency powers, namely the Civil Contingencies Act?
Well, I think we need to draw a distinction between two things. The first is the post-legislative scrutiny of the Act itself, and the second is the post-legislative scrutiny of any regulations made under the Act or the Civil Contingencies Act. So in terms of the Coronavirus Act itself, there are some relatively good mechanisms for post-legislative scrutiny that we have in place. So we have a report which must be made every 2 months on the status of the Act. Then we have the 6-month review by Parliament, and then we have the 1-year review. And maybe going back to your previous question about the accountability in the Act as it was made, The 6-month review is a very good example of the benefit of making something of this nature by Act of Parliament, because the 6-month review itself was introduced as a result of debate and scrutiny in the Houses of Parliament. So when the bill was introduced, there was no 6-month review. The fact that there was proper political scrutiny, political debate, political accountability meant that the government introduced an amendment. So I think that's one of the benefits of having legislation passed by a proper Act of Parliament. So that's post-legislative scrutiny of the Coronavirus Act. If you then look at the Civil Contingencies Act, in terms of post-legislative scrutiny, there's not much of the Act itself, but there is better scrutiny of the regulations that are made under the Civil Contingencies Act of 2004. So, for example, any regulations that are made under the Civil Contingencies Act will automatically lapse after 30 days, which isn't the case with our lockdown regulations. Secondly, regulations made under the Civil Contingencies Act must be laid as soon as possible before Parliament, and they will lapse 7 days after they are laid before Parliament, unless Parliament passes a resolution to approve them. So the post-legislative scrutiny on the Civil Contingencies Act is quite good. Post-legislative scrutiny under the Coronavirus Act is quite good. We haven't really mentioned the post-legislative scrutiny of the regulations, the social distancing regulations, because of course they're made under a third act. But perhaps we can come back to that point if you want to discuss the Public Health Control of Diseases Act later on.
But overall, you feel reasonably happy with the post-legislative scrutiny that's available?
Yes. Now, there are some ways that could certainly be improved, but there is a mechanism for post-legislative scrutiny. There is a parliamentary trigger for debate. There is a process that Parliament must agree to it, and those are very important things. There's certainly room for improvement in terms of the debate around that and the information which could be given to Parliament to assist in that debate. But there is a mechanism which is quite an important procedural safeguard.
Professor Mahar.
Yes, I just wanted to add, I agree with what's just been said about the provisions for the Coronavirus Act. I think the fact that the English regulations and Welsh regulations are not made under the Coronavirus Act is quite important, though, because the lockdown regulations, that is, because the review provisions in those regulations are entirely voluntary. They don't have to be there. And I think it might be worth noting that the committee might be interested in the provision that's been made in Scotland in the second Scottish Coronavirus Act, because that brings into the Scottish Government's 2-monthly reporting duty an obligation to report on all coronavirus-related Scottish statutory instruments. And I think that...
I think we'll come to the devolution issue in due course, but thank you for that. Mr. Hogarth.
I agree that it's a good thing that the government put some mechanisms for post-legislative scrutiny into the Coronavirus Act. I think in some respects those provisions are lacking in comparison with the Civil Contingencies Act. The first thing to say, I think, is that the post-legislative scrutiny provisions in the CCA are more powerful, and they're more powerful partly because, as Dr. Cormacain says, the regulations automatically lapse sooner unless the government seeks renewed parliamentary consent for them. They're also more powerful because if there are defects or problems with the emergency legislation, then under the CCA, it's easier and more straightforward to sort those problems out. You can sort them out by a simple resolution, whereas with provisions of the Coronavirus Act, you could only sort them out by primary legislation, because by and large you can only amend primary legislation with primary legislation, with some exceptions. So the CCA provisions are more powerful. It's good that there are provisions for these 2 monthly status reports, for these 6 monthly debates. It's not good that the provisions, that the duties placed on government to provide information and evidence to Parliament on why it takes the view it does on whether provisions should stay in force or not are so weak. These 2 monthly status reports require the government to tell Parliament whether provisions of the Act are enforced, whether they've been suspended, and also whether the Secretary of State considers the status of those provisions as appropriate. It doesn't require the government to tell Parliament why the government considers the status of those provisions appropriate, and it doesn't require the government to tell Parliament on what evidence that judgment is based. And so I think it would be wise, in the first instance, for government voluntarily to provide a bit more information and reasoning to Parliament than it's strictly required to do so under the Act, and secondly, for parliamentarians to press the government to do so if it's not willing to do so.
Thank you.
Mr. Stevenson, could I just interrupt there, John? Could I just interrupt and follow a follow-up question to Mr. Hogarth, because that's a very, very interesting point that you raise, and one which I raised yesterday evening with the Minister on the floor of the House. Could that be done, for example, by means of a written statement as to which measures were being eased or indeed not being eased, and an explanation for those changes or non-changes?
Yes, I mean, again, it's important to draw a distinction between provisions under the Coronavirus Act and the lockdown measures, which don't, at least in England, don't fall out of that Act. They fall under restrictions regulations, which are made under the Public Health Control of Disease Act 1984. So when you talk about measures being eased, that's normally, you might be referring to provisions under the Coronavirus Act, but that's normally a phrase that people use with respect to lockdown measures, i.e. is the government easing the lockdown? So in a sense, if you bolstered the scrutiny provisions in the Coronavirus Act, that still wouldn't place the government under obligations to explain more thoroughly what it was doing about the lockdown, although that would be very worthwhile in itself as well. As to the mechanism for doing so, yes, I think a requirement to put a written statement before Parliament on a regular basis is exactly the sort of mechanism the government should be thinking about. And I think it would be reasonable for the government, to, as I say, in its regular reports on the Coronavirus Act, provide more information than it's strictly required to do so under the Act, and B, with respect to the lockdown provisions, i.e. the restrictions regulations, provide a written statement at all, which it's currently not required to do by the legislation. In terms of the lockdown, all the Secretary of State is required to do is review the restrictions regulations every 4 weeks. It was every 3 weeks, it's now every 4, effectively to apply his mind to the question of whether these restrictions are still necessary for the protection of public health. There's no obligation currently to tell Parliament, or indeed to tell anybody, about why the Secretary of State has come to the conclusions that he has about whether the measures are necessary, and it would certainly be worthwhile to strengthen the obligations in that regime as well.
Okay, thank you, Mr. Hogarth. Sorry to interrupt you, John.
I think Dr. Cormacain just wants to come back, and then I'm finished.
Yes, I just want to make a slightly broader point about the choice of legislative vehicle which is used to give effect to all these changes. And the very broad idea, I mean, we've got 3 different pieces of primary legislation: Coronavirus Act, Civil Contingencies Act, Public Health Control of Diseases Act, and that's not counting in Wales, Scotland or Northern Ireland. And then we have a plethora of secondary legislation that we can use. And the key, or one of the key questions, I think, is which legislative vehicle is the most appropriate to use to give effect to all these sweeping changes that we're making. The Coronavirus Act made a lot of changes, but a lot of the detailed social distancing rules, the lockdown rules, are all being done by secondary legislation. And the clear distinction is Act of Parliament is something that you will see and debate and scrutinise and amend. The secondary legislation doesn't have that same level of parliamentary scrutiny. It is essentially for you to assent or disagree with it, but there's nothing more to it than that. And one of my concerns is about why really important matters are being dealt with by secondary legislation, not by primary legislation. And I had a look at, there's a delegated powers report that the Bingham Centre did with Jack Simpson-Curd a couple of weeks ago. And in that, flowing on from what Parliament itself has said and what the Joint Committee on Statutory Instruments have said, it was said that politically sensitive matters should in principle be dealt with through primary rather than secondary legislation. So for me, that is one of the major concerns. Why is the departments, the executive, passing all these pieces of secondary legislation which have huge impact upon us, and why is the Parliament not passing those pieces of legislation itself?
Okay, thank you. Interesting point. Thank you, Chair.
Thank you, John. Rachel Hopkins, please.
Thank you, Chair. Just reflecting on the limitations on the proper scrutiny of the coronavirus legislation as it went through Parliament due to the emergency nature of the legislation, has it been appropriately compensated for by subsequent accountability? Mr. Hogarth first.
So, as I've said, I think it has been, with respect to the Coronavirus Act, it's been partially compensated for, insofar as we have these review periods and opportunities for subsequent parliamentary consideration. I think it's worth acknowledging that in any event, sort of ex post scrutiny is a bit of a cheap knockoff of ex ante scrutiny, because of the fact that you can cure problems but you can't prevent them. So as soon as you start talking about ex post scrutiny, you sort of have to be on your guard for problems with the legislation. In terms of whether the compensation with respect to the Coronavirus Act is adequate, my view is that it's probably not, because of these issues that I've mentioned in terms of the level of information that the government has to provide. I mean, what I'd suggest is that the government either provide or voluntarily or be obliged to provide some specific evidence about the use of the powers. So if you take, by way of one example, the quite extraordinary provisions in the Coronavirus Act on social care, which effectively allow for the relaxation of several duties that normally fall upon local authorities to assess the needs of people in their area for care and to provide that care. Yeah, I think the government should be providing information on which authorities have used those easements, for how long they've used the easements. There should be a statement on why the local authority considered that it was necessary to use the easement. And then ideally there should be some quantitative evidence on the impact of those easements as well, like some evidence on the length of time between an individual requesting help and a council finishing an assessment or data on what proportion of requests for care result in the provision of care, and then those data that can be compared against national averages, and Parliament can make some genuine assessment of the impact of these provisions on the ground. That kind of quite stringent reporting obligation is what I would consider adequate compensation for the lack of scrutiny as these measures were going through Parliament.
Thanks. Professor McHarg?
I mean, I would agree with what's been said about the thinness of the first 2 monthly report, and as I was saying earlier, there is an instructive contrast with the Scottish Government's 2 monthly report, which is far longer and far more detailed, and does provide a more detailed analysis of why it's been considered necessary to use particular provisions and the criteria that are going to be used to assess impact. So I think there is a model there that could usefully be drawn upon. I mean, the other sort of ex post scrutiny I suppose we've seen is in relation to the lockdown regulations. These have been subject to subsequent parliamentary approval, although in the case of the English regulations, rather delayed parliamentary approval. And as Raphael said, ex post scrutiny is not as good as ex ante scrutiny because it is virtually inconceivable that Parliament would not have approved those regulations. And under the legislation that's been used, there's no provision for amendment. If the Civil Contingencies Act had been used, and unusually, that does allow for parliamentary amendment of the regulation. So that would provide for a much stronger power. But I think, you know, given that there's no question that the lockdown regulations were required, the idea that they would not be approved and that the approval would be in effect a formality, I think is, you know, is just inevitably that was going to be the case.
Thank you. Dr. Cormacain.
The scrutiny provisions in the Coronavirus Act are quite Spartan, although they are at least there. So Section 97 simply says the 2-month report, the Secretary of State must report on the status of the provisions and whether he is satisfied that it is appropriate, that their status is appropriate. So that's sparse amount of information required as set out in the Act. I had a look at the actual 2-month review, and it is useful, limited but useful, because it does go through all the provisions in the Act, and it says, is this enforced, is it not enforced, and why it is or not enforced. So that, I found that useful information. However, it's only useful to a limited extent, because it doesn't really give the detail justifying why it is still enforced and how effective it has been. And for me, that is one of the key requirements. Not simply is it appropriate that this is enforced, but how effective it has been. And the other point I would say about the 2-month report is it's not properly independent. It's not a proper independent critique of the effectiveness of the measure. It comes across more as slightly self-congratulatory report by the government saying we've done a jolly good job here, because there are words in it like huge effort and well done to the frontline staff. Stuff which is useful, but it comes across as a little bit propagandistic, saying we have done a good job, rather than something which is properly independent and critical and saying this has worked, this hasn't worked. And I think that kind of information would be useful. And the same kind of things apply with the 6-month review. We'll have to see how that works out in practice, but the level of detail required in the legislation is relatively limited. So it would be interesting to see in practice if the government brings proper information, proper evidence, justifying what they have done and being open and honest and saying what has and what hasn't worked.
Thank you.
Thank you, Rachel. If we could go to my colleague David Jones, please. David.
Thank you, Chairman. Mr. Hogarth, first, the Coronavirus Act contains a range of provisions, emergency provisions, to be used in the response to the coronavirus outbreak. Which would you say are among the most exceptional provisions contained?
I suppose I think of the emergency measures in the Act in 3 main buckets. So that the first of those is measures to manage or prevent the spread of disease. And these are probably the most sort of jaw-dropping, eye-popping powers in the Act, insofar as in that part of the Act you've got powers for the Secretary of State and the devolved authorities to close schools and childcare providers, or to authorise local authorities to do so, powers to stop gatherings, close premises, and also powers for public health officers to take enforcement action against individuals who they've assessed as being at some risk of passing the virus on. So that might mean forcibly screening or assessing, or in extremis even detaining them or imposing restrictions on their movements or their activities or their contacts. So that first bucket is those are probably the most striking emergency measures. The second bucket is a bucket of measures to lighten the load or the burden on public services during the pandemic. And although those measures might appear a bit less jaw-dropping, they're actually pretty extraordinary and quite powerful in some cases. I've already mentioned the provisions allowing for the suspension of duties on local authorities under the CARE Act. If a local authority triggers those provisions, then its duties to assess and provide care are relaxed to a duty to do that only when not doing it would infringe somebody's human rights. And there are various other public service duties that are relaxed, basically to make the lives of those delivering public services a little bit easier when it's anticipated that they might have a depleted workforce and depleted resources. So, there are some duties relaxed with respect to vulnerable children, duties relaxed with respect to the regime for those who are mentally incapacitated, the registration and certification of deaths, things like that. And then the third bucket of measures, some economic support, protecting tenants from eviction, some statutory sick pay provisions and so on. Although at this point, most of the kind of economic response is being done outside the Act rather than with provisions under the Act. So those measures are important, but this isn't the place to go to understand the government's economic response.
Professor McHarg.
I would agree with Raphael's categorisation. I would maybe add a fourth category of provisions under the Act, which we might call sort of suspension of normal constitutional practice. So there are provisions providing for the postponement of by-elections, suspension of local authority meetings, and you might also put in that category the Treasury directions power, which I think should be regarded as a pretty extraordinary power, because this is being used to spend a huge amount of public money on the furlough scheme, but without parliamentary scrutiny, with some question mark over this, the legal status of a Treasury direction. Is it a form of secondary legislation? What exactly is it? So that would be my fourth category.
And Dr. Cormacain.
I would add very briefly on that, in terms of exceptional measures in the Coronavirus Act, closing schools and delaying elections seems to me to be quite extraordinary. But I think the broader point I would make is it's not simply the Coronavirus Act that gives effect to all these changes, it's all the regulations that have been made outside the Act itself. So if you go onto the government's website, at last count, there was something like 160 separate pieces of secondary legislation with coronavirus in the title, and they were all doing really key critical things. And it's those secondary pieces of legislation which aren't necessarily being properly picked up. And then we have other legislation. There's a bill before Parliament today, the Corporate Insolvency and Governance Bill, which is being debated today in the House of Lords. And even though it's called Corporate Insolvency and Governance, it also contains coronavirus measures in it, maybe quite sensible things about a temporary restriction on the rules on company meetings or when you have to file accounts, things of that nature. But it also contains coronavirus rules. So it's like an octopus with its tentacles spread out across the statute book. So many different rules and laws which have been made as a result of coronavirus, and they're spread out everywhere. And if we focus simply on the Coronavirus Act or even on the regulations, then we miss out some of those really important changes that have been made within society.
Thank you.
Thank you, David. Back to Rachel Hopkins.
Thank you. The government is committed to publishing in good time to help inform the 6-month debate on the Coronavirus Act sufficient information. But what information does Parliament need for that debate? Mr. Hogarth, or anyone, sorry.
Well, if I can answer first, I think that is a really good example of, as I said before, Parliament actually working. Whenever the coronavirus bill was going through Parliament, I worked with Lord Anderson to suggest an amendment to that provision, and that amendment would have required concrete information for the government to provide. Now, unfortunately, that amendment wasn't taken forward. But the key things I think you need are, what was the original justification for that, for each individual measure? Why did we have that provision? Then the second question is, is that still justified? And then the third piece of information is, what is the evidence for the effectiveness of that provision? So to take an example, there was a relaxation on the rules on doctors' registration, and the idea behind it was to allow retired doctors to come back into practice so there'd be more medical support for the NHS. It needs to be explained that was the original justification, and then for the 6-month review, the government need to explain, is that justification still necessary? Are we still down on doctors? And then the third thing is the effectiveness. has that been effective? How many doctors have come back? Are they working properly? Are they de-skilled? Do they have to be retrained? What kind of jobs are they doing? Are they providing an effective backup? It's that level of granularity about the effectiveness for each provision in the Act. So the government need to be able to explain what we did, why we did it, and is it working? If it's a financial measure, if jobs have been protected, how many jobs have been protected, how much has it cost? Really what we're talking about is quantified evidence to prove the effectiveness, because then you as parliamentarians can do your job and scrutinise and question those things.
Professor, next, I think you said you wanted to come in?
Yes, thanks. I mean, I agree with what's been said. I think a useful way to think about this might be to think in terms of impact assessments. So to require the government to go through a proper impact assessment for each provision. So as Ronan said, what was the purpose of the measure? What alternatives might there be? And I think that at this stage is extremely important. Are there less intrusive ways of achieving the same ends? What's the evidence as to what impact the measures have had, and so on. And as part of that, I think you'd want a proper equalities impact assessment as well. Parliament might also want to think about prioritising its reviewing process. So, which are the provisions that are of greatest concern? And in terms of thinking about the categories of extraordinary measures in the Act, I suppose I would place at the top measures which have impacts on human rights and equalities, which reduce necessary protections, which have coercive effects. I would also, I would then prioritise the kind of unusual constitutional practice provisions, and I personally would be least worried about things like, power to require information about the food supply chain. Things like that would not be terribly important to me. So I think thinking in terms of impact assessments and also prioritisation of Parliament's resources and Parliament's scrutiny time as well.
Thank you.
I think I agree with everything that's been said. I gave the example earlier on of the sort of information, in particular quantitative information, that I would seek on individual provisions such as the Care Act provisions. I also agree with and want to draw attention to what Ronan said about workforce. If you go back and look at the Hansard debates for the second reading of this bill, or really any part of its passage through Parliament, an extremely important aspect of the government's justification for the legislation, in particular with regard to all of its provisions relaxing duties on public services, was the risk of a depleted workforce due to people basically being ill or having to self-isolate. So a really important aspect of the evidential picture is going to be what has the impact on workforce been in public services and in government. The one thing that I would add on the information that Parliament requires is, in addition to this important quantitative evidence, it'll be important to get qualitative evidence from people on the ground affected by these measures, from service providers, from the third sector, from schools, this sort of thing. And it's important, I think, that in advance of the 6-month review, departmental select committees and other select committees like this one assist the government in collecting that evidence, really, calling witnesses, asking people what the impact of the measures is on the ground, because I think that would be really an excellent way to build the evidence base and enable parliamentarians to make the most informed possible judgment when the 6-month review comes about which of these measures still need to be enforced.
Thank you. And just thinking about when decisions need to be made about whether temporary provisions should expire, is there anything you'd like to add about the sort of criteria that should be considered?
Yeah, I mean, I think there are basically, for a lot of the provisions in the Act, there are basically 2 key justifications that the government brought forward, which is, first of all, this is going to mitigate and deal with the impact of staff shortages, which I mentioned, and secondly, that these measures are going to contain and slow the spread of the virus. And so if you assume that those are the bases on which Parliament agreed to pass this Act with quite little scrutiny at breakneck pace, then those are the key criteria against which the measures should be judged, and in particular whether they're still necessary, and exactly as Professor McHarg said, I think, the least harmful or the least interfering way of achieving those objectives when considered against available alternatives.
Thank you. Professor?
I've got nothing to add.
Just one additional point on the 6-month review. It is a little bit of a blunt tool because it is simply whether Parliament passes a motion to accept or not accept, and that doesn't really allow for individual decisions about individual provisions, and that would have been much more helpful for you to debate. For example, do we need the power to investigate the food chain? Do we need the power to relax the rules on social workers being registered? It's a fairly blunt yes or no, and in all honesty, I can't see Parliament simply throwing out the whole Coronavirus Act, because I'm sure there's some bits of it that we will still need. So that lack of granularity or individual decision making is, I think, a bit of a defect really on that 6-month review provision.
I think we might explore that later. Thank you. One final question from me. I'll start with Professor McHarg. Do you think the government has a clear roadmap for how the temporary provisions in the Act will be turned off?
Well, if it has one, I wasn't able to find it. There are some high-level principles in the COVID-19 recovery strategy, but there isn't that level of detail in the 2-monthly report. Again, contrast with the Scottish Government's approach, where they are at least promising in their next 2-monthly report to publish a framework for analysis, a framework of how they might approach that kind of issue. So, I mean, I think this is one area where you probably do need a set of overarching principles, but then you also need to drill down to each area, because the considerations that apply to different powers will be different. So I think having a detailed set of criteria for each set of powers is necessary, and as I say, if it's there, I haven't been able to find it.
Thank you. Dr. Cormacain.
I agree with the Ealing. I not really qualified to say, but it does seem to be a little bit haphazard. Now, that's inevitable in a crisis that we don't really know what's going to happen next and what measure will work, but there doesn't seem to be a clear and coherent strategy to remove measures in a particular order or in response to particular criteria.
Thank you.
I have nothing to add to that.
Okay, thank you, Vogue.
Thank you, Rachel. We go now to my colleague, Tom Randall, please. Tom.
Thank you, Chair. And well, my question is on the 2-monthly report, which I think you've all sort of touched on at various points up until now. But in May, the government published the first 2-monthly report on the non-devolved provisions in the Coronavirus Act. Could you tell me how helpful you found that report, and what other information the government ought to publish in any subsequent reports? Dr. Cormacain first.
I think I've touched upon this earlier, but just to briefly recap, useful but limited. Useful in the sense that it gave a brief description of each provision, and it said if it was enforced or not enforced. So that in itself is useful. So for example, I learned that the powers around the food supply chain are not enforced, and then a very brief explanation of why it was enforced or why it was not enforced. So that was very useful to have that piece of information, but in terms of a greater level of detail, not as helpful, because it didn't really have the hard quantifiable data saying how effective was this measure, how effective would it have been if we had tried something different. And the only requirement on the Secretary of State is simply a statement to say what is the status and is that status appropriate, which is very little in terms of scrutiny. But to give credit to the government, there was much more detail about the government's general approach, but the tone of that approach was a little bit self-serving, and it didn't have the necessary ring of independence or authority that I think would allow you to rely upon it properly, because it was a little bit too much of congratulating themselves rather than proper independent questioning. And if you take, let's say, a body like the UK Statistics Agency, which has made quite some critical reports about government, and that nearly makes it more independent and more trustworthy, because they won't simply follow what the government has said. Or something like the Office of Budget Responsibility, which is semi-independent of government, which means that they don't simply regurgitate or repeat or reiterate what the government has said. There is more independence. So I think if there was some sort of mechanism in that 2-month review for some independent or semi-independent analysis of how effective the provisions have been, that would make the monthly review much more useful.
Thank you. Mr. Hogarth, did you want to add to that?
I agree with Dr. Cormacain's overall assessment of the 2-month reports. The first one is primarily descriptive. It's a sort of Coronavirus Act on the ground 101, but not much more detailed than that. The idea of introducing some independent aspect of the process, I think, is an interesting one. But one of the things that I find frustrating when reading the 2-month report is, in one sense, that it's not partial enough, in that I would like to see the government making its case in that report for why it has come to the view that it has come to on the appropriateness of the status of provisions. And I think it's important that there is a forum in which for the government to do that. There is a forum in which for the government to say, here is our evidence, here's why we think we need these provisions, here's how the evidence supports our view, and then parliamentarians can scrutinise that evidence base and that reasoning. So in a sense, I'd sort of like to see more partial reasoning in the 2-month status reports, albeit not the kind of sloganeering propaganda that Dr. Cormacain said he was worried about.
Professor McHarg?
So I mean, I agree with the limited usefulness of the report. It's not unuseful, but it's of limited usefulness. We've talked earlier about the kinds of additional information that could be usefully included. I said earlier, I think it would be useful to extend it to all coronavirus-related legislation, including secondary legislation, or at least the more important aspects of that. And that is something that Parliament itself could possibly give a steer on as to what it's most concerned about. In terms of independent scrutiny, I have some concerns about time, the impact on the timeliness of these reports. So I think I would probably agree more with Raphael that having some subsequent process for scrutinising by Parliament or by a parliamentary committee of these reports would be maybe more appropriate.
Thank you. Thank you, Chair.
Thank you, Tom. Now, it falls to me for a couple of questions related to the lockdown regulations, and first of all, specifically, changes to those so-called lockdown regulations. I want to ask, first of all, about the use of the urgent procedure, and that's to say without consulting Parliament, if we're talking about scrutiny. And can I ask Mr. Hogarth first, his view, was this urgency and lack of consultation justified, Mr. Hogarth?
No, I don't think it was. I think throughout the process, when the government introduced the lockdown regulations, and on each occasion when it's amended those regulations, it has used that urgent procedure, i.e. Has enacted the new legislation before consulting Parliament, and then held a debate in Parliament to approve the legislation after the fact, on some occasions when that legislation is already in force, and in fact on some occasions when the legislation has stopped being in force because it's been replaced by new legislation. And I think there are a few problems with that. I think first of all, it's just objectionable in democratic principle for kind of major changes in the law touching on the most fundamental and intimate aspects of human life to be enacted by ministerial fiat rather than by the legislature. But once you get away from that abstract principle, I think there are also several practical problems that this approach to legislating has generated. First of all, it just leads to mistakes. If parliamentarians had a chance to have a look at the first set of restrictions regulations, they might have spotted things like the fact that there was a power for the police to enforce some of the restrictions with reasonable force, but not others. They might have tidied that up. They might have raised concerns from constituents about certain reasons for going outside that might not have been covered by those regulations that maybe should be, like going to an ATM, which was subsequently inserted in a set of amendment regulations. They might have asked the government why some of the rules about when you could go outside that appeared in the regulations were so different from the guidance that the government was putting online and that was being delivered by ministers to the public in press conferences. So a bit of proper scrutiny might have ironed out some of those mistakes. Second of all, and this may be something that we get onto later in more detail, if you proceed using secondary legislation in this way, then you might introduce statutory instruments that are unlawful. And the restrictions regulations, that is the lockdown rules, may still be found unlawful by the courts.
Yes, that's right, Mr. Hogarth. Thank you for that. We are going to touch on that. I think that's a very pertinent point that you raised, and we will be coming on to that shortly. But could I ask Professor McHarg, please, to give her view on the use of the urgent procedure?
I find myself in two minds on this. On the one hand, I think there are undoubtedly considerations of urgency here, and I think that applies not just to the initial imposition of the lockdown, but actually also to the lifting of the lockdown. These place extremely significant restrictions on people's human rights, and so those restrictions need to be lifted as quickly as can possibly be managed. In addition, I think we have to be mindful of the imposition on drafters and on civil servants to come up with these regulations. They're not sitting and twiddling their thumbs, not bothering to publish things. They're working on these really round the clock and up to the wire. So I think there are arguments for urgency. On the other hand, I completely take Raphael's points about the fact that if there had been at least some opportunity for ex-ante scrutiny, then some of the problems might have been picked up. We have seen very, very heavy use of judicial review, resort to judicial review on all sorts of issues in relation to COVID-19 regulations and guidance, and some of those have produced changes in the guidance. And from my point of view, I don't think that's very desirable. I don't think people should have to threaten to go to the courts to resolve issues that might have been picked up earlier. So I think we are in difficult territory. It would obviously not be appropriate for the normal affirmative resolution procedures to apply. Those take too long. So whatever process that's available has to operate within relatively restricted timeframes.
Thank you. And Dr. Cormacain, any reflections on the use of the urgent procedure from your perspective?
Yes, I think the very first set of lockdown regulations, it was appropriate to use the urgent procedure. There was a clear need for it to happen, and the executive was entirely justified to use the urgent procedure to make that happen. However, as the lockdown has progressed, I think there's less and less justification for using that urgent procedure, and it seems to be simply a habit that the government have got into, that this is the way to do things. And when we're reaching this stage, there's less and less obvious need for a particular relaxation that is said to be urgent. And just to give one very specific example, the number 2 amendment regulations for England were the things which, it seems so long ago now to be honest, but this was relaxing the rules on outdoor exercise. They were made on the 12th of May. Then the number 3 regulations were made on the 31st of May. Then the number 4 regulations were made on the 12th of June. And then it was debated in the House of Lords on the 15th of June. So the House of Lords were debating something yesterday which had been superseded by 2 different sets of regulations. the thing that they were debating was literally pointless. It had no effect, but yet they were expected to debate it anyway. And that sort of time delay between the government making something by the urgent procedure and something then getting into Parliament to discuss, it seems to make a little bit of a mockery of the whole point of democratic scrutiny. So the longer things go on, the less validity there is, I think, for these things to be done by the urgent procedure, by secondary legislation, and the greater the need for Parliament itself to properly debate them. And if I could just make two broader points on this. I've been reading a paper from the Czech Republic on the use of their emergency legislation, and the author there made two really good points. He said that Parliament is really good for providing legitimacy for the lockdown regulations, because you get to debate it, you ventilate the views, you scrutinise it in public, and that means people will be listening and hear the justifications for doing that. When we have lockdown regulations, we don't have that legitimation function. And the second point is the effectiveness point, because whenever an act of Parliament is made, your constituents, lobbying groups, interest groups, NGOs, they will write to you and say, this has this particular effect in my sector or my community or my area, and this is a really bad thing to do. And then you have the opportunity as parliamentarians to lobby and to change that. And that works with primary legislation, with acts of Parliament. But when everything is being done by secondary legislation and using the urgent procedure, you don't have that direct ability to effect that change, to make the legislation more effective.
Could I just ask on that and the delay there, Dr. Cormacain, because yesterday the Commons, yesterday evening, debated the number 3 regulations, which has a 2-week lag period. Great fan of hypothetical questions sometimes. What would have happened had the Commons declined that regulation yesterday evening?
If they had declined it, we would have been in a very awkward constitutional position, because the number 4 regulations were already in force on the 12th of June. So you would have a slightly awkward situation where it's like a building, the first floor, second floor, third floor, and the second floor has suddenly been removed, but you still have the third floor in place, and the third floor might not quite work on top of the second floor. So the bits that the executive have done in the number 4 regulations would still be effective, but it might not really work properly because the bits of the number 3 regulations have been removed. So the answer is, it's all very messy, and you would have to have some very complicated way of working out what was going on. But I think that perhaps makes the point that the parliamentary approval is a fairly blunt instrument, because I can't imagine Parliament refusing to approve regulations simply because there would be chaos if they did so. And that perhaps indicates why secondary legislation is far too blunt a tool for making these really important constitutional changes.
Thank you. That's a very pertinent observation. I'm grateful for that. Could I just move us on? And Mr. Hogarth, you were touching on this before I rudely cut you off. Could I just ask about the extent to which there's a risk that the original lockdown regulations were ultra vires of the Public Health Act 1984? Mr. Hogarth?
Yeah, so I think there's a substantial risk that the initial regulations were ultra vires, which is to say that the government didn't have the power under the parent legislation, the Public Health Control of Disease Act 1984, to enact the restrictions that it did enact. And the issue in sort of very summary terms is that parent legislation gave the government the power to make regulations imposing restrictions on persons or groups of persons who may be infected concerning where they go or with whom they have contact. Didn't have the power under that legislation to put anybody into isolation or quarantine, and that's made quite clear in the legislation. The legal questions are basically, first of all, can you really say that the entire population is a group of persons? Secondly, can you really say that the entire population may be infected with coronavirus? And thirdly, can you really say that telling people they can't leave home except with reasonable excuse or for particular purposes is a mere restriction on where people go or with whom they have contact, or does it look like a rather more fundamental restriction than that? Obviously, to some extent, the question whether those initial regulations for ultra-vires, it's becoming more academic because the restrictions are changing. And I suppose that the risk that the regs for ultra-vires is getting lower because as the regulations get less restrictive, it becomes more and more likely that these restrictions are mere restrictions on where people can go or with whom they can have contact.
So would you, sorry to interrupt you there, Mr. Just on that point, do you therefore believe that the most recent lockdown regulations have a much diminished risk or still a certain risk of that same problem?
I think there's still a certain risk insofar as it's still the case that the current regulations are only lawful if the entire population constitutes a group of persons who may be infected with coronavirus. And you can still, I think, legitimately question whether that's really a proposition that you can sustain with common sense. The risk is lower because that other point that I mentioned about whether the nature of the restriction goes further than the Act allows, I think that worry is lessened by the fact that the restriction itself is now not as stringent as once it was. It's no longer the case that you can't leave home except with reasonable excuse. That's
extremely. I'm grateful for your answer, Mr. Hogarth. There, so to press you. Could I ask just reflections from our two other members of the panel, starting with Professor McHarg, please?
Yes, thanks. I just add a few qualifications. I suppose one is to note that the potential challenges to the validity of the lockdown regulations are not just on whether it's ultra-vires, the parent act, but there's also the possibility of human rights challenges, so arguing that they constitute disproportionate interferences with a whole range of different convention rights. So the other qualification is in relation to the strict binaries question. It is a question of how you read the legislation. I think we have to bear in mind that there might be slightly different issues in relation to the Scottish and the Northern Irish regulations than in relation to the English and Welsh regulations. Because the Scottish and Northern Irish regulations, although the powers are very, very similar to under the 1984 Act, these are powers conferred under the Coronavirus Act. And I think that context changes how you would read those particular provisions. I think it's much more plausible in those circumstances to say, well, yes, it was in contemplation that these would be used for whole population lockdown measures. Now, if you're in the situation of saying, well, on one reading, the English and Welsh regulations may be ultra-vires, but the Scottish and Northern Irish ones are intra-vires, I think you're in problematic territory. I think you're also in problematic territory with any suggestion that these regulations are ultra-vires, because the consequences of that are extremely serious. I mean, potentially, if the regulations are quashed, which is not inevitable, but it's a possibility, that would open the government to enormous potential financial liability. You would have huge financial liability for interferences, unauthorised interferences with convention rights. You could possibly have a number of very, very costly claims from businesses for interference with contract and so on and so forth. So I am somewhat sceptical that a court could be persuaded to strike down these regulations given the consequences and given that it's not unarguable that they are intra-vires.
Thank you, Professor. Dr. Cormacain, please.
I would generally agree with what Aileen has just said. And I think I would disagree with Raphael, certainly in the very first set of regulations. The regulation, the power to make regulation is for preventing, protecting against, controlling, or providing a public health response in respect to infection or contamination. So those are the the VARES set out the Public Health Act 1984, and I think if we take a broad purposive approach, what was the purpose of that Act in 1984 is to prevent the spread of disease. What is the government in those regulations, what it has done? It has sought to prevent the spread of disease. So I don't think, I would therefore conclude that the regulations on the Public Health Act were intra vires. But perhaps that's setting the bar at quite a low level, really, and perhaps Parliament might want to consider not simply have we just scraped through and said that this is lawful, but is in accordance with good democratic lawmaking practice. And whenever you consider that, then you consider, really, is this something that Parliament should be doing themselves rather than relying upon the executive using an urgent procedure?
Thank you all for that. Yes, Mr. Hogarth, yes, quickly, please.
So, I mean, I absolutely agree with what's been said. I think that a court would be really reluctant to find these regulations ultra vires. All I'm saying is that I think that there was a risk, a genuine risk, that they were ultra vires. I think the government ought to have been aware of that risk, and in the circumstances where there was that risk, it's quite surprising that the government proceeded using a pretty legally risky procedure rather than just doing this under primary legislation, and so avoiding that risk, especially given that the day that the Prime Minister announced the lockdown to the nation was the same day that primary legislation on coronavirus was going through the House of Commons anyway.
Yeah, thank you for that. To my colleague, Lloyd Russell-Moyle, please. Lloyd.
Hello, how are you doing? During the original lockdown measures, the government initially said that people should restrict their exercise to once a day, although this was not explicitly required under the regulations. And there were some rumblings that it should be about an hour, but again, that was never fully explained. And on the 10th March, the Prime Minister said people could take unlimited exercise, could sit and sunbathe, but there were no changes to the regulation. Does propose a risk for the rule of law and create a system where you have curtain twitching vigilantes more able to enforce a kind of social law than actually police or authorities in any kind of written law. Maybe Rowan first.
I think that's a really excellent point, and it's a question that I've posed several times in a couple of blog pieces. And the example of the change, the so-called change in the exercise regime, is, I think, extremely problematic for the rule of law. So, just to confirm, the rules, the actual law said that you can take outdoor exercise. There was no limitation on the frequency or the duration of that exercise. So that was very clear in the rules. I should add a slight caveat to that, the rules in England. In Wales, they did have a rule which said you can exercise once per day, and that's a perfectly acceptable decision to take on either side. The huge difficulty was that the government said you can exercise once a day, and then Michael Gove came out and said you can go for a run for 30 minutes or you can go for a cycle for an hour. That seems reasonable to me. The only people who can make the rules are you in Parliament, sitting as a Parliament. That is the source of authority. This is going back to sort of Constitutional Law 101. This is going back to the Bill of Rights, 1688. It's for Parliament to decide what happens to make the law. It's not for the executive to simply speak and that becomes the law. And that became even more problematic because we have a real conflation of what the rules say, what the minister says the rules say, what the guidance is, and what the guidance represents as sensible advice, and what the guidance says is a rule. And throughout the course of the pandemic, there has been a huge conflation of the two things together. So going back to the exercise rule, on the 12th of May, the rules changed that you can exercise with one person from another household. But the Prime Minister said, we have changed the rules, you can have unlimited exercise. Well, that's simply not the case. And the actual coronavirus FAQ on the government's website said, we have now changed the rules so that you can exercise outdoors as much as you wish. Well, that is a complete misrepresentation of what the actual law says. So I think it's really bad for the rule of law if it is seen to be the case that what comes out of the mouth of the minister is, by virtue of it coming from the mouth of the minister, an actual law, because that abrogates the rulemaking power of Parliament to make these rules. And as one slightly related point, if I may, there's been a lot of discussion about the 2 metre rule. There is no such thing as a 2 metre rule. I actually went online yesterday just to check that I haven't imagined this, but in England there is no such thing as a 2 metre rule. However, if you go to Wales, there are 16 references to a 2 metre rule in their regulation. If you go to Scotland, there are 6 references to a 2 metre rule in their regulation. If you go to Northern Ireland, bizarrely, there's a 2 metre rule for attendance at burial grounds when you have to keep 2 metres apart, but there's no other reference to it. There is a huge amount of misrepresentation, mischaracterization of what's happening. If something is really important, make it a law. It was important for the Welsh and the Scots and the Northern Irish to have a 2 metre rule. They put it into their regulations. If it's not that important, don't make it a law, but don't characterise something as a rule whenever it's not a rule.
Thank you very much. It's even more confusing because they say 2 metres or 6 foot, of which they're not the same measurements. So you have 2 different measurements, even in England, that are about to be used. And you mean one contradiction, of course, not what ministers say, but what ministers' advisors do as well, I expect, causes confusion about what the regulations are. Mr. Hogarth, do you have views on this?
Yes. I mean, I've got a little bit of sympathy for the government on the guidance issue, insofar as if you go back and look at the SAGE minutes for late March and look at the advice that the government's behavioural scientists were giving on the guidance as it stood then, there was obviously some concern in government that the guidance was basically a bit soft. It said things like everyone should try to follow these measures as much as practicable. And the scientists said, don't tell people to try to do it, just tell people to do it. And don't introduce ambiguous phrases that are open to interpretation, like as much as is practicable. It's not surprising that the government wanted to state what people ought to be doing to restrict the spread of the virus as clearly and unambiguously as possible. I think the problem the government had is that it started mistaking being clear and simple for being wrong. And it started using some mandatory language on its website and in public statements when really it was just giving advice. So, it should have been saying, we advise you to exercise only once a day. You should not travel far from your home when you do exercise. It shouldn't have been telling people you must not, because in so doing, it was implying to the public, and I think also to the police, that these were legal restrictions, and they weren't.
It seems strange to me on the 10th of May, when the PM announced that you could exercise with other people. My understanding was that you could always exercise with another person if you were social distance. So it's almost like on the 10th of May, they were introducing restrictions that never existed, that they were then lifting, which was extremely confusing to people who had been doing those things already, and an element of guilt. I was by the law, not necessarily what ministers were pronouncing or not. Do you think, Aline, that this is a particular problem for the rule of law if we don't quite know where people stand and the authorities don't quite know where the law stands even?
Well, I mean, I think there is a legitimate role for poor guidance here, actually. I mean, there is a very important accessibility justification. I mean, ordinary people cannot be expected to go and read regulations. They need some accessible source of the rule. I think it is perfectly reasonable to use guidance where an enforceable rule would not work. So for the advice around hand washing, for instance, it's perfectly appropriate for that to be guidance, not legal rules. How could you enforce it? even the 2 metre rule as well. I mean, there are circumstances in which in the Scottish and Welsh and Northern Irish regulations there are references to it, but it's not a general rule, and it would be impossible to enforce as a general rule. You know, if I'm within 2 metres of somebody, is it my fault? Is it their fault? What if, to avoid it, I'd have to step out into a busy road? It's difficult to make that an enforceable rule. So I think that's perfectly fine. I think it's also perfectly fine to give interpretive guidance, so I have no problem with the legal rule being you can leave the house for exercise, but guidance being we recommend that you do so only once a day, or for no more than an hour, or within your local area. I have no problem with that. Where problems arise, I think, are in 3 situations. One is where the distinction between the legal rule and the guidance is not made clear, and clearly that has those 2 things have been confused repeatedly. Secondly, it's obviously highly problematic if the guidance contradicts the legal rule. It's different from and just wrong in that case. Again, you are misleading people as to what they're permitted to do. And again, that has happened. And the third thing that is really problematic is when the police are attempting to enforce the guidance and not the law. If you want to make it enforceable, it has to be in a legally enforceable form, and that appears to have been a messaging problem, a training problem, one which I think has got slightly better, but perhaps not been eradicated completely.
I must say, to be fair on the police, the initial actions may be confused, but there were clarifying guidelines that the police then issued themselves based on the law because it was so confused. Dr. Ronan, your hand up.
Yes, just one minor point to illustrate. Eat 5 portions of fruit and veg a day. Very sensible public health advice and guidance, but no one is going to be confused that they're going to be arrested by the police for not eating their 5 fruit and veg a day. With the coronavirus advice, the whole thing is bundled up together into a package, laws and guidance, with the very strong implication that these are all laws that you must follow. And certainly, you point out quite rightly at the start, there were instances of the police thinking, well, I heard the Prime Minister saying it, therefore it must be a law, therefore someone must be punished or penalised, criminalised for it. So I think it really does undermine the rule of law. Certainly, I absolutely see the really important role for sensible guidance and health advice, as long as it is set out as, we recommend that you do these things, and then clearly, you must do these other things.
The 5 fruit a day is an interesting analogy, because it's about personal welfare. And with someone, it's not just about personal welfare, but doing this for a greater good. Could there have been a better distinction on what you should do for your personal welfare, i.e. we recommend that you exercise? There was there's no greater good particularly to exercise apart from your personal health and seeing the NHS maybe down the line, compared to what people actually needed to do for the greater good in terms of advice. So not just in terms of a legal distinction, but in the advice as well, there needed to be more nuance for people to be able to have a confidence in abiding by it.
I think that's a question that's probably better directed at a behavioural psychologist, yes. A way to encourage people to follow the rules. But certainly, if there is a clear moral undertone to things, then people are more likely to follow them.
Yeah, no, you're right. Look, moving on to a slightly different question. The lockdown, the government recently changed the review period for lockdown regulations from 21 days to 20 days, effectively adding a week, saying it will allow decisions to align more closely with the period to assess the impact of previous changes, because how long it takes for the R rate and other things and the death rates to come out. Do you think this is justified? And do you think the government is publishing sufficient data for us to be able to scrutinise and review these decisions at the end of each lockdown, whether it's 21 days or 28 days? There's no point having extending it if data's not there. Raphael?
So on the first question of whether 21 days or 28 days is more appropriate, I don't know. That's really a question for a public health expert who could take a considered view on how long the data, how long you need from the point when a rule is changed to see the impact of it in the data. On the question of whether the government is publishing sufficient info at its review periods, I think the government has got really a lot better on this. If you go back and look at what the government said in the first couple of review periods, particularly the first review in mid-April, the government statement was essentially, we have received advice that relaxing the restrictions currently in place would risk a second peak, and so we're not going to do it. There wasn't that much discussion of the evidence underlying that conclusion and judgment. Obviously, the government came under quite a lot of pressure to publish more information, particularly in its press briefings, about numbers of cases, numbers of deaths, testing, admissions. It is now doing that, and when the PM announced changes to the rules around gatherings in a press conference, he supported his conclusions on each of the government's so-called 5 tests for relaxing restrictions with evidence relevant to that test. And I thought that was a much better way of approaching the review period than what we'd seen in earlier reviews. I think there are just a couple of issues outstanding. One of them is that the government has now placed itself under a couple of different conceptual frameworks on which it proposes to justify changes in the rules. So on the one hand, you've got the coronavirus alert levels, and there's some suggestion that the government will change the rules if the alert level changes. And then on the other hand, you've got the 5 tests for relaxing the rules, which are not the same as the alert levels. And I think there's potentially a little bit of confusion about what reasoning processes ministers are going through in order to make decisions on this, particularly given that in any event, those alert levels and tests are really only about a public health picture anyway, and there's clearly increasingly some economic dimension to these decisions as well. The other issue, and I know I keep banging on about parliamentary scrutiny, but I just still think it's wrong and strange that the provisions for these reviews are for reviews that take place inside the minister's mind, outside Parliament. In my view, it would be more appropriate. It would still be more appropriate and more consonant with our broader emergency legislative framework for the minister to have to come to Parliament with the results of these reviews, say something about the review, and get a view from Parliament on the conclusion that he's come to.
Could I rudely interrupt and just say that? Could I rudely interrupt? Just say that there are. I'm grateful for all of this, but there are bonus points for concision in our questions and our answers. If we could press on. Thank you. Sorry to interrupt you there. For the next member of the panel.
Perfect. Yes, Professor Eileen.
In the interest of concision, I don't have very much to add. I would just say that I think one of the things that's probably encouraged greater justification and scrutiny of these review decisions is divergence between the 4 UK nations, because then you have evidence that a different political calculation could be made, or that a different interpretation of the expert advice could be made. So in those circumstances, I think it's not surprising we're seeing a greater attempt to justify greater scrutiny.
Dr. Rowan, is there anything?
I have no particularly strong views on the 21 to 28 day change. One very minor additional point in relation to the rules and guidance issue. I was giving a webinar to the business network of the Banking Centre last week, which was to advice to in-house company lawyers, and I told them that they should basically ignore what the government says and instead look at what the actual rules say. And that was because of the difficulty of knowing what the actual law is by reference to what a minister said, and how it's much more important to look at the actual source of the rules themselves.
Thank you so much, Lloyd. Tom Randall, please.
Thank you, Chair. If I could move on to the Civil Contingencies Act. The government said that the Civil Contingencies Act could not have been used for the measures to address the coronavirus pandemic. Professor McHarg, do you agree with that analysis?
It's not entirely clear why they thought that. It seems to me that the nature of the pandemic clearly does fall within the scope of the Act. Section 19 clearly envisages an event which threatens severe damage to human welfare, including loss of human life and human illness, so it's within the scope of the Act. There are some conditions on use of the Civil Contingency Act Part 2 powers. There needs to be an emergency that has occurred or is about to occur. That needs to be necessary to make provision, and that needs to be done urgently. I think where the problem might arise, though, is that you can't use the Part 2 of the Civil Contingencies Act if there's existing legislation in place that is suitable to use and can be used appropriately quickly. So I suspect that may have been the issue, that given the existence of the powers under the 1984 Act, the view may have been taken that they shouldn't use the Civil Contingencies Act. Now, of course, as has already been said, the powers under the 84 Act only applied to England and Wales. Lockdown powers had to be taken for Northern Ireland and Scotland under the Coronavirus Act, but it would have been it was perhaps thought to be more consistent with devolution to act via fresh primary legislation subject to devolved consent, rather than the very UK government-centred approach under the Civil Contingencies Act, which requires consultation with devolved authorities, but not consent. So I think that is probably the issue. There is a general assumption in the Cabinet Office guidance that the Civil Contingencies Act will only be used in very extreme circumstances. So the assumption is that if you have existing powers, you use those existing powers.
Do you think given this experience, do you think the Civil Contingencies Act is fit for purpose?
So I'm going to preface this by saying I'm by no means an expert on emergency powers. I think it depends on, I think it may be fit for certain purposes. So one of the criticisms you find of the Part 2 powers is that they assume a very kind of top-down command and control model. And the argument is that that's not appropriate in many circumstances where relevant powers are dispersed, whether that's dispersed amongst devolved authorities or local authorities or private sector parties or other bodies. So the Cabinet Office guidance suggests the use of the Civil Contingencies Act only in the most extreme circumstances where that kind of top-down approach is appropriate. I mean, I think the other thing you might say about fitness for purpose is that, like a lot of framework legislation in the UK, this is in effect an opt-in. So it's used or not used as government sees fit. If it can use other legislation or it can get Parliament to enact new legislation, it doesn't have to use the powers under the Civil Contingencies Act. We see that in relation to the Inquiries Act, the Statutory Instruments Act, all sorts of framework legislation. But if that's a defect in our constitutional arrangements rather than a defect in the Act.
Thank you. Dr. Cormacain?
Simple answer to your question, in my view, the Civil Contingencies Act could have been used. I looked at the criteria for the exercise of powers under it, and as Ailing has said, all those criteria have been ticked for me, and I don't see why it couldn't have been used.
Mr. Hogarth?
Nothing to add to that analysis.
Thank you, Chair.
Thank you, Tom. David Jones, please.
And continuing that discussion, we've already discussed whether the use of the 1984 Act might have been ultra vires. Why do you think it was used as opposed to the Civil Contingencies Act to impose the lockdown restrictions? Mr. Hogarth, please.
I think there are probably a couple of reasons. I think, first of all, with respect to the lockdown restrictions, there may have been some worry in government about a provision of the Civil Contingencies Act that says that you can't use the CCA when you have a power to do the relevant thing already, unless it would cause serious delay to rely on that existing power or might be insufficiently effective. So there may have been some worry about that. I suspect that the decision not to use the CCA and to rely on the 1984 Act instead was primarily driven by a more political reasoning that using the CCA really feels like slamming the hammer through the glass, and acknowledging that this is a proper bona fide emergency, and I suspect that the government was just reluctant to use a piece of legislation that everybody knows is for the worst kinds of emergency, that's never been used before, if it could avoid using it.
Professor McHarg?
Yeah, I mean, you see several suggested reasons. So the regulations under Part 2 of the CPCA can only remain in force for 30 days, so that might well be regarded as too short. Yeah, as Raphael said, there seems to be a general reluctance to declare an emergency. Some people have suggested that it was motivated by a desire to avoid the scrutiny provisions in the CCA, or more charitably by a concern that it might not be possible to actually meet the parliamentary scrutiny requirements for practical reasons. The Parliament might not actually be able to meet. And as I said earlier, this is kind of the very sort of top-down, almost militaristic command and control nature of the legislation was probably regarded as inappropriate for this kind of emergency, particularly given that key powers in relation to health, particularly, but other powers as well, rest in the devolved nations. So the idea that the UK government could kind of bypass them, I think, was really a non-starter.
And that might have resounded particularly in Scotland, I guess.
Perhaps.
Dr. Cormacain.
Very briefly, there are greater safeguards and greater scrutiny rules for Parliament under the Civil Contingencies Act. And if the executive wanted to ask to be more charitable about it, if the executive saw the need to act nimbly, fast, without recourse to Parliament, then they can use the Public Health Control of Disease Act. But if you have to go through the Civil Contingencies Act, Parliament has a greater role. It can amend things. Things lapse much more quickly, and Parliament has to approve them 7 days after they are laid, rather than 28 days. So there's a greater role for Parliament to have some say in things if you go by the Civil Contingencies Act route.
Thank you.
Thank you, David. Karen Smith. Karen.
Thank you, Chair. Just picking up the last point about devolution, it was, of course, the case that the government got into some problems with regard to Northern Ireland and differences across the island of Ireland. So that bypassing issue, I think, is pertinent not just to Scotland, but Wales has done different things, and the Northern Ireland situation is also difficult. But my question, to move devices, is about what will happen if the Coronavirus Act does lapse. What could be covered in the Civil Contingencies Act? What would it pick up? And I also, Dr. Cormacain, if you could add to your earlier point here about, I think you said 160 pieces of secondary legislation now on the government's website, and how on earth we, if the Act lapses, how we pick up those as well as the provisions in the Act. And perhaps if I start with you and then Professor McHarg.
I think the point about the volume of legislation is a really important one. I said 160, that was probably last week, it's probably 200 by now, because more and more regulations are being added on each day. And these aren't necessarily really key things about restricting personal liberties. It's the little sort of minor technical points, for example, relaxing the rules on financial instruments so that you can make loans without going through the necessary procedures, the little sort of minor tweaks. And they aren't all being made under emergency powers. Some of them certainly are. We talked about the lockdown rules. They're being made under emergency powers, but a whole host of other legislation is being made through a different way. One very useful thing that the government has done is on its the legislation website for government, there is a list. You can search for all legislation which has the word coronavirus in the title. And if you do that, it's relatively easy to find this very, very long list. So that is something certainly that is to the credit of the government. But one of my concerns is that emergency law is normally seen as a separate, distinct body, which is separate and distinct from the ordinary laws and shouldn't really contaminate the ordinary laws, because it's the kind of things that we wouldn't do in ordinary time. And there is a serious risk at the moment, I think, with emergency laws and ordinary laws starting to mesh together. So I gave the example earlier of the Corporate Insolvency and Governance Bill, which is before Parliament now. You wouldn't know from the title, but half of it is about coronavirus. And even reading the table of contents, you can't easily figure out, is this a temporary measure in respect of coronavirus, or is this a more sensible long-term process? And then the fact is that that bill has gone through Parliament in something like 20 days because it's seen as important for coronavirus, even though it doesn't have coronavirus in the title, and even though some parts of it are nothing to do with coronavirus. So there is that real danger that our ordinary constitutional process for making laws has been mixed together with the emergency process, and that is something that does greatly concern me, because ordinary laws should be separate from emergency laws, and they should be subject to proper parliamentary scrutiny and debate.
So just to come back on that, because the heart of, I threw in something else, but the heart of that was about, if the Coronavirus Act lapsed, what would we pick up by Civil Contingency Act? But part of what you're saying is because of the meshing and confusion, that in itself will perhaps be more complex. Professor Hartmark,
yes, it'll require a lot of unpicking. I mean, if the Coronavirus Act is repealed tomorrow, then there's still a lot of rules will disappear, but a lot of rules will remain outstanding because they're made under lots and lots of different powers. Sort of in devolution terms, if the Coronavirus Act disappears, then the changes made in Scotland and Northern Ireland, the lockdown rules, they will automatically disappear as well, because they are made essentially under the Coronavirus Act. However, in England and Wales, those lockdown rules will still remain. So there's a bit of a strange overlap there, and that the English and Welsh regulations will continue onwards. And in direct response to your question, if the Coronavirus Act is repealed, then there seems to be much less justification for using the Civil Contingencies Act to make emergency laws anymore, because if we've got rid of the Coronavirus Act, it's not really an emergency anymore, and if it's not an emergency, we can't really justify the Civil Contingencies Act, in which case we're back to ordinary, normal legislative processes throughout the 4 jurisdictions of the UK.
Thank you. Professor McHark, do you want to add?
Yeah, so Ronan has just made the point that I was going to make, that if in the 6-month review period there is no need for the Coronavirus Act, then there is no need to use the powers under the Civil Contingencies Act. Of course, however, things could change, in which case there may be a range of other statutory powers which could be relied on, or the Civil Contingencies Act could be used. There are some substantive limits on that power, but it is very, very broad. So it's an extremely broad power, subject to some limitations. You can't introduce conscription, you can't outlaw industrial action, there are limits on the kinds of criminal offences that can be created, you can't amend the Human Rights Act. But if the conditions, the triggering conditions apply. It's a very, very broad piece of legislation, very broad regulation making power.
Thank you. Mr. Hogarth, do you want to add to?
I agree that if you did try to use the CCA, there's probably a lot of the Coronavirus Act that you could bring under the CCA, but that if you had got rid of the Coronavirus Act, it would be highly inappropriate to do so. But before we leave the CCA, there's just one more thing that we haven't really touched on that I think is quite important, which is that a particular feature of making legislation under the CCA is that it can be struck down for incompatibility with human rights, whereas primary legislation can't be struck down for that incompatibility. The courts can say it's incompatible, but the legislation still has force. And so just one, that's a potentially quite powerful safeguard that we lost by not using the CCA. And I think that's something that the government needs to be mindful of going forward in its implementation of the Coronavirus Act. It needs to make sure that it's adopting quite a constructive posture on any human rights challenges to what it's doing under the Coronavirus Act, effectively attempting to remedy any potential incompatibility rather than defending itself against allegations of unlawful conduct. Because, you know, if we'd proceeded with our kind of pre-existing emergency framework under the CCA, a human rights challenge would be available.
Thank you all. Thank you, Chair.
Thank you, Karen. I wonder if you want to carry on with your next question, please. We've just had a slight rejig, if that's all right with you to carry on. Thank you ever so much.
Sorry, witnesses know we're rejigging without rejigging. Yes, we wanted to come on to talk about part one of the CCA, which has not been looked at much, and category one responders. And I remember in 2012-13 working in the PCT to CCG changeover on emergency planning, and there was a great deal of concern voiced by the experts at that point around lack of capacity in the system to respond to an emergency. So local authorities, the police, NHS ambulances, the Department of Work and Pensions, even the fire brigades, all were driven to take out capacity, both buildings and background managerial staff, out of the system. We talked with the Secretary of State to Gove recently, who talked about the Civil Contingencies Secretariat in the Cabinet Office being not directly responsible for assuring risk mitigation plans, but where necessary, departments or local responders could alert to the obligations under the CCA. So essentially this disconnect between the very local and Cabinet Office government where we as MPs scrutinise. So the question is really about whether we were prepared and how we as MPs can scrutinise part one of the Act and understanding what's really happening with regards to the capacity and the ability of those local responders to respond. I don't mind who wants to take it first. Mr. Hogarth, do you want to go first on that?
So I caveat anything I say on this with the point that a lot of evidence on this is going to emerge later. I have colleagues at the Institute for Government who are doing some work on the preparedness of public services, looking among other things at how well Part 1 worked. It's very, very early to say very much about this. But I think there are a couple of things we can say. First of all, I mean, it looks from the early picture like compliance with the letter of everybody's Part 1 duties was quite good. So authorities had assessed risk, had plans to mitigate risks in place. The question is really whether compliance with those duties was good enough to prepare those responders for the emergency. One thing that I think bears on that is quite a lot, an unusual amount in recent times of emergency planning in some respects have been done because there'd been a lot of planning for a potential no deal or no trade deal Brexit. So in some respects, those plans were very helpful insofar as responders had looked at things like food supply chains, medical supply chains. In some respects, obviously, planning for one potential eventuality saps resource away from planning for others. And so I imagine we'll find that that there are some bits of contingency planning that didn't get done because resources were being used in other places. In terms of scrutiny, as you say, the way this is meant to work is that local responders are effectively plugged in to the machinery of central government. So at the local level, you have local resilience forums, which are sort of connecting those actors on the ground who might need to respond to an emergency, sharing information, sharing practice, and when they need to channel information up or get instruction down from Cabinet Office, basically from the sort of COBRA structure, they can do that. So I think one important question to ask is how effective was that channeling up of information and channeling down of instruction? I also think that we need to have a careful look at how transparent authorities are being about their Part 1 planning. So insofar as planning had been done for pandemics, were those plans published? Was there any opportunity to scrutinise them? We're obviously aware of the fact that there were some high-level simulation exercises for a pandemic in the form of Operation Cygnus, the results of which weren't published. So I think we also need to take a look at how transparent the government is being about its emergency planning and whether there's any way of improving it through greater scrutiny.
Thank you. Dr. Cormacain, do you want to?
Yes, very briefly. I'm not really qualified to answer that question, so I'll just make one or two very brief observations. If we have the second or third highest number of deaths in the world and one of the highest death rates per capita in Europe, then clearly we weren't prepared. And on an anecdotal level, my wife's a GP and her cousin is making face masks and delivering to her so that she can spread them around her practice and patients. So we're not, on that very anecdotal level, I don't think we're prepared.
Professor McCarg. And really about the scrutiny that we have on that preparedness, the link, how do we, in this forum, get down to that level?
Again, I've got nothing really sensible to add on that, other than to point out that under Part 1 of the Civil Contingencies Act, preparedness responsibilities are shared between the UK and devolved governments. So any scrutiny needs to take account of that devolution dimension.
Thank you. Mr. Hoke, can I go back to you on, because you mentioned Operation Cygnus, which we have discussed in other forums as well. Do you think when we do get to the bottom of what came out of that, we will be able to get a picture of how those local preparedness plans meshed together?
Well, it's incredibly difficult to comment from what we'll learn about it before we've seen it.
Could I just interject on that? Excuse me, could I just interject on that? I can tell from my experience at the Cabinet Office last week that the leaked report on the Guardian website is exactly the same as the official report. So we need not detain ourselves too long on that particular question. Sorry, because I'm just conscious of time. Yep. Was there anything else at all, okay. Karen?
No, that's fine. Thank you.
Excellent. In which case, on the devolution subject, can we go, please, to David Mundell?
Thank you, Chairman. Can I begin with you, Professor McCarg, and perhaps actually follow on to a response that you gave to Mr. Jones? Do you believe that the framework in which the arrangements have been made across the UK involving the devolved administrations was really the only way which could have been adopted in relation to these issues, given the proportion of issues that were devolved?
Well, you can answer that from different perspectives. So from a legal perspective, if the UK government did not want to use its powers under Part 2 of the Civil Contingencies Act, but wanted to take control of the competencies currently exercised at devolved level, it would have had to pass primary legislation giving itself those powers, which would have been subject to the Civil Convention, and I very much doubt that consent would have been forthcoming. The devolved governments have been very willing to cooperate with the four-nation approach, but cooperation, of course, does not mean takeover. So the legal problem could have been overcome, but not without difficulty. I think, for me, the more pertinent issue, though, is the kind of capacity issue. So, health, education, justice system, etc., social care, these are all devolved matters, and it just seems to me to be unrealistic to think that the UK government could suddenly step in and start running these devolved public services. That just doesn't make sense. Now, of course, on the flip side, there are capacity limitations and legal competence limitations for the devolved governments. There are certain things that they could have done unilaterally, but not everything. So it seems to me that the approach that was taken of attempting to cooperate was the sensible one, and it's the approach which the Cabinet Manual on emergency responses assumes. It assumes that there will be a coordinated response respecting the division between reserved and devolved matters. Now, whether that has worked perfectly, I think, is a different question. Whether there has been sufficient clarity of messaging, whether there has been sufficient consultation and genuine cooperative decision making, is a different issue. But in terms of the principle of the approach, I think it's perfectly reasonable. I think the other thing maybe is worth mentioning is that we've seen in many other countries regionally differentiated approaches. So that in itself is not unusual. And insofar as there are, and clearly as the pandemic has progressed, there are different political choices to be made about how you balance the risk to health versus the risk to the economy and so on and so forth, then accountability for those decisions also matters. And the primary accountability for the devolved governments rests in the devolved parliaments. That could be quite significantly bypassed if the devolved governments were simply acting under dictation from the UK government.
But an issue which I think Mr. Jones might touch on in a moment is it's quite difficult for the public to understand exactly who is accountable when there are a whole range of messages, sometimes conflicting messages, being given to them, and that. But I'll allow him to ask that question. On a more technical matter, what would be the impact on the devolved administrations if the temporary provisions in the Coronavirus Act lapse?
Well, the devolved provisions, the provisions which affect clearly devolved matters, are not subject to the 6-monthly review provision. So they are expressly excluded from it. So the only risks to the devolved administrations are from the lapse of UK-wide powers, and that's primarily the Treasury direction. So the furlough scheme is really the big one, the various social security decisions, and the ports power, although I don't think that's been used. But the bits of the Act which are clearly devolved are excluded, so there is no risk of those lapsing without the decision of the relevant devolved administration.
Okay. I mean, we've touched on the benefits or risks of adopting a separate but coordinated approach compared to a centralised UK decision-making approach. I mean, do you think that we have managed to achieve the optimum approach across the United Kingdom, considering the devolved arrangements that are in place?
Well, clearly there have been some problems in messaging. Now, I think that's probably been less of an issue from the point of view of the devolved nations, because we're used to the fact that decisions are announced as if they're for the UK when they're actually for England. And I think, well, certainly in Scotland, which is where I am, I think the Scottish Government has been quite good at kind of getting its announcements in first, so that people up here are clear what it is that is different. I think the UK government quite clearly has not been so good at certain times, particularly around about the shift from stay home to stay alert, that the decisions it was making were decisions for England only. And so that did give rise to some problems where, you had people crossing borders into Wales, not realising that the rules may be different there. Although some of those problems, about people sort of crossing the Welsh border to go to the beach, I think those go back to our earlier discussion about confusion of law and guidance. I'm not sure that actually was contrary to the law. On the other hand, if somebody today were to try to travel from London to Edinburgh to take advantage of bubbling with another household, they would find that bubbling is still not permitted in Scotland, so that they would be, any attempt to bubble would be unlawful.
Yes, well, I'll be very careful not to bubble when I go back to Scotland, of course, unless the First Minister announces on Thursday that well, not me specifically, but I'm sure others across Scotland are allowed to bubble. Could I ask our other witnesses, whether they feel that we have achieved an optimum outcome in relation to achieving a UK-wide approach whilst respecting the devolution settlement?
I think that it's a necessary byproduct of devolution that there are different rules in the different jurisdictions, and I agree wholeheartedly with what Ealing has said. Decisions are probably best taken at a local level, so Scotland can do its own thing. And speaking as someone who also drafts legislation for Northern Ireland, sometimes certain things need to be done for Northern Ireland which would fit better for Northern Ireland but wouldn't work for Wales or England or Scotland. So it's a necessary consequence of that you will have different rules in different parts of the UK. It certainly should be coordinated. One additional point I would just make is about the capacity and resources of the devolved jurisdictions if they were to go on a radically different path to the rest of the UK. So we did have a huge amount of difficulty in Northern Ireland with the Renewable Heat Initiative scandal, where the Northern Ireland government took a different route than the rest of the UK and ended up with a lot of public money being wasted. And the judicial inquiry which came out of that said that Northern Ireland should be very careful that it has the capacity and the capability and the resources if they want to do something quite different from the rest of the UK. So that's the only slight caveat, I would say, the slight problem with doing something quite different in one of the devolved jurisdictions from the rest of the UK.
Sorry, can I just come back on that? I mean, capacity is important. Financing is extremely important as well. I mean, it's all very well to say that Scotland and Wales and Northern Ireland might maintain the lockdown or reimpose the lockdown, but if there isn't the financial support coming from the UK level, then that becomes very, very difficult. I mean, it may be possible, technically, in Northern Ireland and Scotland, where there are social security powers, to do something equivalent, not the same, but equivalent, but that would have huge financial costs. So the powers, the legal powers of the devolved governments here are constrained both, as Ronan said, by technical and expert capacity, but also by financial considerations.
Mr. Hogarth?
Just to add one very brief point, which is that I think the most difficult and controversial aspects of a differentiated response or a localised response are probably still to come, insofar as, although so far there has been some differentiation in different parts of the UK as a result of devolution, the government has suggested that the next phase of its response will involve significantly more differentiation, which is to say there will be powers somewhere to impose restrictions at the hyper-local level, perhaps even a local authority level, in response to local outbreaks of the virus. And I think there are probably lessons from confusion of messages between different parts of the UK that we can learn once that happens, but also I think it would be quite useful if the government sometime reasonably soon, told us something about how that system was going to work, on what legal powers it was going to be based, and sort of what the regime for those sort of hyper-localised differentiated responses was going to be.
Thank you, David.
I could ask my final question.
If you could do, David, I'd be obliged. Thank you.
And then leave it to Mr. Jones. And what about, because I think that touches on it, Mr. Hogarth, do the provisions that we have in place allow sufficiently for different decisions to be made at different times across the UK as we move into as we move through the disease? And for example, are we clear that if a part of the UK determined that there was a need for a further lockdown or a tightening of the lockdown, that could be done, subject to the points that Professor McHarg made earlier in relation to the financial consequences of doing that?
Yeah, I mean, I think it depends on what you mean by part of the UK. So if what we wanted was for measures to change in one of the devolved nations, then there are powers under the 1984 Act, which the devolved administrations have already been using, which allow for plenty of differentiation. If we wanted differentiation at a more granular level, so to be able to impose a mini lockdown in one local authority or one neighbourhood, then I'm not sure the powers are there at present. There are powers under the Coronavirus Act, as I mentioned earlier, for public health officers who could be in local authorities to impose restrictions on individuals they've assessed or tested. And there are also powers for local authorities to apply to the Magistrates' Court to impose restrictions on groups or on individuals or groups of individuals. I'm not sure the current framework would let local authorities impose a lockdown of the type we had at national level, but at local level. So, if the government does want that to be possible, I think we're likely to see further legislation.
Okay, Professor Mahar, yes.
Sorry, just to clarify that, I think the regulation-making powers under the 1984 Act probably could be used to impose localised lockdowns, because they talk about groups of people. So groups of people could be, and they can be in particular geographic areas, but those would be lockdowns imposed by the UK government on particular local authorities. Similarly, a similar approach would be taken in the devolved nations.
Dr. Cormacain, have you anything to add?
Just one very brief point. There's a lot that can be learned from and across the individual jurisdictions. So the English regulations fixed the loophole that the Northern Ireland regulations haven't spotted and fixed yet. The Scottish and the Welsh have done really useful stuff on a 2-metre rule. The Northern Ireland regulations had a special provision allowing a wedding for someone who's on the verge of dying, a relaxation of that rule. So there's a tremendous amount of learning that can be got between what the different jurisdictions have done, and you can say, well, that was a really great idea in Wales, let's put that in Northern Ireland, and this can go across all of the 4 nations.
Thank you very much.
Thank you, David. Now, we've been storing up Jackie Doyle-Price, and the virtual floor is hers. Jackie.
Hello, right, we've had a marathon 2-hour session, so my final question is really that we're looking increasingly like we'll have a public inquiry of some kind into how the government's handled this whole pandemic, and I just wanted to really see what your views would be about what the terms of reference of such an inquiry should be and what kind of format might be effective. So perhaps I could start with you, Mr. Hogarth, on that one.
So I think that there's a conversation to be had about the terms of reference of, if you like, the big inquiry. I think that a very pressing matter is to hold a smaller, rapid review as soon as possible, and this is something that the Institute for Government has advocated, in order effectively to learn lessons from the first wave. Because full public inquiries can take a pretty long time. There can be lots of argument about what the eventual report says, and if there is a risk that the UK or any part of the UK experiences any kind of second wave, then we can't really afford to wait for that process to run its course. So what we've suggested is that the government set up a rapid review, not necessarily under the terms of the Inquiries Act, and has that review pretty narrowly focused, not necessarily on apportioning accountability, but just on learning lessons and how to do it better if another wave happens. And that review should be conducted by experts in public health rather than individuals who might be better suited to apportioning accountability, like a senior judge. And then I think, to some extent, if the government does that, and we do get an opportunity to learn lessons, then there'll be an opportunity to have a more detailed conversation about the terms and structure of the big inquiry and make sure we get that right.
Yeah, it's the challenge of being fleet of foot, whilst also being thorough, I guess is really the challenge. Did you like to have any observations, Professor McHarg?
So yeah, I mean, I agree with the sort of two things that are said there. That there's a question of what is the purpose of an inquiry, and there could be multiple purposes. So I absolutely agree that sort of preparing for the second wave, I think, would be very, very important. There will be duties under Article 2 of the ECHR for particularly deaths of healthcare workers. That's a different kind of inquiry. There could be an inquiry into the whole question of preparedness. There could be an inquiry into the state of emergency legislation and how we deal with that. So, which of these things need to be done at different points, I think, is important, and probably not trying to bundle everything up together, because that will just delay and cost a fortune and not be as useful. So I think I'd be inclined to parcel up the different purposes into different inquiries or different processes. Dr. Cormacain?
Very briefly, need for an independent chair, scientific input, and a focused question for any review, for any inquiry, and perhaps it might be worthwhile considering not apportioning blame as a way to actually get to the best result. So not so much what did you do wrong, more a case of what can we do better the next time, and that might produce a less defensive attitude from government, Public Health England and the NHS, for example.
I mean, just looking at particular models, I mean, on the basis of what you said, I think we've got obviously the CSA style inquiry, which is multi-layered, and there's a series of reports. You could also have a Hillsborough style panel, which can be very focused and probably quicker, or a judge-led inquiry. Do any of you have any thoughts on which of those models would be more effective? Mr. Hogarth? We're doing some work on this at the Institute, and I don't want to prejudge the findings of that. So I think we're firm views on what needs to happen now. In terms of the best models for the long-term inquiry, I think there's more work to be done on that. I think there's a particular challenge in designing the bigger inquiry that doesn't always arise, or doesn't often arise, with public inquiries, is that you're effectively going to have the government commissioning an inquiry into itself. It's going to be, still the sitting government, and so it's going to be more important and potentially more difficult than normal to ensure that inquiry is robustly independent and has all of the powers that it needs to inquire into the events of the pandemic response properly. Thank you, Dr. Cormacain.
One possible model for an inquiry, I should say I don't really know which is the better model, but one possible model was the Hart inquiry into institutional child abuse in Northern Ireland, which worked very well, it seemed to me, because it was relatively focused, didn't direct itself so much to blaming individuals. It was more a case of finding out what happened and what went wrong, rather than pointing a finger, although criticism may be inevitable as a result of that sort of inquiry. But anecdotally, it's nearly good to have a grumpy judge who doesn't really care what government thinks and just goes ahead and does what is necessary to be done, rather than worrying too much about what the government think. And again, we don't really need an inquiry that spreads out over a large amount of subject areas. It's much better if it's focused on particular questions, which would prevent it from taking forever and not really getting anywhere.
And finally, Professor McCarg.
I agree with the need for independence, but there's a balance to be struck between independence and credibility. So, I mean, that to me would suggest probably a panel approach rather than a single inquiry person doing the inquiry. So that might include a judge, but also medically qualified staff, also people with experience in public administration. A balanced panel that gives it that credibility as well as independence.
Thank you.
Thank you. Quickly from David Jones, please.
Yes, and do you think that such an inquiry should ideally include the work of the devolved administrations, and would it be legally possible to set up such an inquiry?
Is that to me?
Yes, please, by all means.
Well, so, I mean, anything is legally possible if it's authorised by primary legislation.
Would you require the consent of the devolved administrations then?
Would it require the consent? I'm going to duck that question because I want to look more detail at exactly what the reservations say. I don't think there's any relevant reservations, but there might be. I mean, I think certainly one element would be that question for a big inquiry would be that question of how we've managed relations between devolved and devolved governments and UK government, and what it tells us about the adequacy or otherwise of the intergovernmental decision-making framework. But that might not be something that you'd want to. That might be something you'd want to do separately.
Could you maybe let us have a note on that point, Professor?
Okay, I'll have a look at it.
Thank you.
Thank you,
Dr. Cormacain. Do you want to add to that?
Very briefly, I think you could probably do it UK-wide, or each devolved jurisdiction could do its own one. I think any possible defect could be cured by passing a legislative consent motion by each of the devolved jurisdictions, which would avoid the need for that sort of bun fight between them. And I think it would be a little bit insular to have simply separate inquiries for separate parts of the UK, because so much of what we've done is the same and is reliant upon the same advice.
Anything to add, Mr. Hogarth?
Nothing to add.
Thank you.
Thank you very much. Thank you, David. Thank you to our three witnesses for that very thorough session. I'm grateful for you sharing your expertise with the committee. There may be a couple of things that we may follow up with you, and I think David Jones's final question was one such things to Professor McHarg in writing, and if you could reply your earliest convenience, we'd be very much obliged. So it remains to thank colleagues and to thank our witnesses and the broadcast team here in the committee room. Order, order.
The proceeding has ended.